Hare Krishna. Welcome to Tax Guru YouTube channel. This is C. Rohanar Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. And welcome to the video series What Law Says. And today we are going to discuss one case law in depth under direct tax. So let's dive into it. Let me allow to share my screen. What law says, in-depth analysis of case law. So today's discussion focuses on landmark international tax case, which deals with taxability of centralized hotel marketing and reservation contributions received by a non-resident US hotel brand company from its Indian affiliate. Very, very important. What we are going to discuss today is a landmark international tax case which deals with taxability of centralized hotel marketing and reservation contributions received by a non-resident US hotel brand company from its Indian affiliate, and whether such receipts are taxable in India under domestic law or under the India-USA double tax avoidance agreement. So this case is important because it deals with cross-border payments for services and interpretation of fees for included services under Article 12(4) of the DTAA, that is Double Tax Avoidance Agreement, and Section 9, Subsection 1, Clause 7 of the Income Tax Act 1961. It lies at the intersection of international tax treaty interpretation, nature of services, and consistency of judicial precedent. The Delhi High Court's decisions reinforces established jurisprudence regarding the non-taxability of certain centralized service receipts when no technical or managerial services are made available to the payer. Very important, made available to the payer. So let's start with it. First, let's see case citation. CIT, that is International Taxation versus Six Continents Hotel Incorporation. Relevant assessment year is assessment year 2020-21. Order dated 17th April 2025. And relevant sections are Section 9, Subsection 1, Clause 7, Section 143, Subsection 3, and Section 144C. And DTA Article 12 for India USA double tax avoidance agreement. So let's see what are the facts of case. So appellant was Commissioner of Income Tax, International Taxation, Revenue, and respondent was the Six Continents Hotel Incorporation, USA-based company, part of Intercontinental Hotel Group. As already said, assessment year is 2020-21 and order dated was 17th April 2025. So under this received during the financial year 1920, the assessee received approximately 28.11 crore from its Indian affiliate, Intercontinental Hotels Group India Private Limited, comprising what? Marketing contribution, priority club receipts, reservation contribution, holidays fees, and these payments related to centralized marketing, loyalty programs, and reservation services. So assessment proceedings under that, assessee filed a revised return declaring what? Modest income. AO held the receipts taxable as a royalty and alternately as fees for included services, that is FIS, under Section 9, Subsection 1, Clause 7 and Article 12, Subarticle 4, Clause A and B of the Double Tax Avoidance Agreement. Additions were made to the income. DRP observed that the assessing officer's draft order and DRP rejected the assessee's contention that such receipts were not taxable, especially claiming implemented new business model changes from April 2019. So, what ITAT held was the tribunal allowed the appeal in favor of the assessee, noting the consistent historical position and lack of sufficient evidence showing technical or managerial services made available. So, revenue filed appealed under Section 268 before Delhi High Court, challenging the tribunal's order. So now let's see what were the issues. Okay, before that, let's understand the legal provisions involved. Under the domestic law, section 9, subsection 1, clause 7 of the Income Tax Act 1961, that is the income deemed to accrue or arise in India, includes fees for technical services provided by a non-resident where such services are utilized in India. And section 143 subsection 3 and 144C deals with this pertain to the assessment procedure and DRP adjustments respectively. Under double tax avoidance agreement between India and USA, Article 12, Subarticle 4, Clause A and B, this deal with the definition and scope of fees for included services, that is FIS, payments for managerial, technical, or consultancy services when such services are made available to the payer in a relevant manner under the treaty. Now, moving further, let's see what were the issues under consideration. The High Court framed the core question whether marketing or reservation contributions received from Indian affiliate are taxable in India as a royalty or fees for included services, that is FIS, under the India-US DTAA and domestic tax provisions. So specifically, whether such receipts involve provision of managerial or technical services that are made available to the Indian hotels and therefore taxable under section 9 subsection 1 clause 7 and article 12 subarticle 4. So let's moving further, let's see what was the argument by the parties. Let's first see the revenues arguments. Receipts are akin to the what revenue argued that receipts are akin to the royalty or technical fees since marketing and reservation services are ancillary to the brand use. The services provided by the assessee allegedly involved technical assistance, coordination, and such services are in effect made available to the Indian hotels. So, mere classification as a marketing receipt should not absolve taxability if such services are inherently technical or managerial, is what revenue argued. Let's see what assessee argued. The assessee argued that the receipts do not involve any technical knowledge, skill, or managerial services being made available to the Indian hotels. They represent pooled contribution. What argued main argument of assessee was it represent the pool contributions from franchises and are used centrally, that is global brand marketing, with no additional service benefit provided to the Indian hotels individually. So no transfer or application of know-how or a managerial systems exclusively for Indian hotels benefit. So now moving further, let's see what High Court observed and held. So the High Court observed that the core question is not novel and the issue has been repeatedly considered by the Delhi High Court in similar hotel chain cases. For example, Sheraton and Westin, etc., wherein payments for centralized marketing or reservation were held not taxable as royalty or FIS under double tax avoidance agreement. The receipts received by the assessee do not involve managerial or technical services that is made available to the Indian hotels simply by virtue of brand use or global marketing contribution. Mere granting of brand rights doesn't automatically equate to the technical services for FIS under treaty. Services must enhance the capability of the payer to apply technical or managerial know-how by itself. So the consistent historical trend were also similar to the issues were not appealed by revenue for multiple years strengthens the view that no substantial question of law exists. Very important. So High Court held that the appeal was dismissed, no substantial question of law arises. Marketing and reservation related receipts are not taxable in India as royalty or FIs under Section 9, subsection 1, clause 7 of the Income Tax Act 1961 or Article 12, sub-article 4, clause A or clause B of the India USA DTAA. So from this, let's see what principles we can lay down. What principles this case law laid down. So non-taxability unless services made available. For FIs under DTAA it is not sufficient that the payments relate to the brand or centralized services. The foreign enterprise must demonstrate that the services are actually made available to the Indian payers. Substance over form. Transactions involving pooled contribution for global programs without distinct service benefit to the individual Indian hotels are insufficient to attract the tax under Article 12, sub-article 4. So consistent precedents also carry the weight. Judicial consistently across the multiple cases involving hotel chains strengthens the taxpayer's position that the centralized contributions absent specified services do not constitute taxable fees under double tax avoidance agreement. So what implications? What are the practical implications? International hotel chains receiving similar revenues can rely on this and similar precedents if no technical services are made available. Issues involving DTAA interpretation on FIs or royalty require what careful analysis of services objectively provided. Tax planning around the franchises or brand related contributions must ensure what clear contractual terms to define nature of services rendered. So conclusions that can be drawn is that CIT versus six continents in the relevant case is a high watermark on how Indian courts interpret the fee for included services, vice versa, centralized marketing or reservation fees. The Delhi High Court reaffirmed that not all cross-border service-related receipts are taxable unless and until there is a clear evidence that services are actually provided and made available, very important to the payer in India. This underscores the importance of substance over form, contractual clarity, and judicial consistency in international tax disputes. So that's it for today. Thank you. Thank you so much for patient hearing. Hope you are getting a valuable knowledge from this video series. Please note down my contact numbers. If you have any questions, observations, suggestions, then do let me know via WhatsApp, email, or you can also comment below the video. Thank you. Thank you so much once again. If you're not yet subscribed to Tax YouTube channel, then do subscribe it and please also share the video so that it can reach to the mass public, means interested public. So thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.